When you transfer a standard legal contract, the buyer inherits all the hidden liabilities of the seller. If the seller doesn't actually own the underlying asset, the buyer buys nothing but a lawsuit. Any ownership defect passes down the line, ruining the asset for subsequent holders. To bypass this trap, the negotiable instrument acts as a legal shield. When transferred, it cleanses the title. The new buyer receives unblemished ownership, insulated from previous defects. By definition, this is a written document guaranteeing the right to receive a specific amount of money, optimized to change hands as easily as physical cash. The real utility here is the legal insulation that transforms a static, risky debt into a highly liquid, protected financial asset. The specific algorithm that governs this liquidity in India was codified in the Negotiable Instruments Act of 1881. This legal technology has facilitated global trade for centuries. You can see the mechanics operating on historical documents, relying entirely on the binding weight of a written promise to pay. The 1881 Act established 3 distinct frameworks to manage this flow of capital: promissory notes, bills of exchange, and checks. Navigating corporate finance requires knowing exactly how each of these 3 structures dictates the flow of risk, and who is ultimately left holding the liability. To ensure these documents move quickly without endless court battles, the Act hardwires strict presumptions into every transaction. The law automatically assumes that valid consideration was given, that the date on the document is perfectly accurate, and that all endorsements are legitimate. This places the burden of proof entirely on anyone trying to challenge the debt. The most direct application of these rules is the bipartite model. This is the promissory note. It operates entirely on an unconditional promise between 2 parties, a maker who creates the debt and a payee who collects. For this to hold up legally, it must be written, physically signed, and restricted to an exact sum of money only. You cannot write a promissory note payable in goods or services. Because the maker drafted the document and made the promise, they carry direct primary liability. It is the leanest architecture in the Act. The creator of the paper generates the value by personally absorbing all the legal risk. By introducing a third party, the architecture evolves into the bill of exchange. The structure expands to include a drawer, a drawee, and a payee. Notice the mechanical shift. The drawer is not promising to pay. They are issuing an unconditional order, demanding that the drawee pay the payee. But you cannot unilaterally force debt onto someone else. The drawee is not legally bound to pay anything until they formally sign the document, which means they accept the order. Once they do, they become the acceptor. The moment that happens, the liability flow reorganizes. Primary liability shifts to the drawee. The drawer now holds only secondary liability, stepping in only if the drawee defaults. Looking at this 1863 tripartite instrument from Suriname, you can see the density of signatures and stamps required to validate these complex multi-party orders. This allows a merchant to pay their supplier by ordering their customer to foot the bill, clearing 2 debts with a single piece of paper. If you take the bill of exchange and apply strict operational constraints, you get the check. The first constraint locks the drawee. In a check, the drawee can only ever be a specified bank holding the drawer's funds. The second constraint locks the timing. A check is strictly payable on demand. There are 0 credit periods and no future payout dates. To prevent a thief from simply cashing a stolen document, the drawer can use crossing, drawing 2 parallel lines on the face of the check. This violently reroutes the legal path of the money, forcing it out of the cash system and directly into a secure, traceable bank account. Any mechanical system has vulnerabilities. The Act has protocols for handling human error and structural failure. Consider the inchoate instrument. If you sign and deliver a stamped blank paper, you legally grant the holder full authority to fill in the amount. You become entirely liable for whatever number they write down. The same strict logic applies to agents. If an agent signs an instrument but fails to explicitly write that they are acting on behalf of a principal, the law traps them. They absorb the debt personally. A minor lacks legal capacity and cannot be held liable for debt. They can safely endorse an instrument to move it along, but the competent adults surrounding them in the transfer chain remain fully exposed to the liability. The Act refuses to let structural edge cases destroy the liquidity of the paper. It ensures that the debt always finds an adult, competent anchor. When we synthesize the rules governing these three instruments, a complete matrix of liability emerges. This matrix shows the architectural divide. The note requires two parties and is built on a promise. The bill and check require three parties and operate as orders. Because bills target third parties, they uniquely require formal acceptance. Time instruments, like notes and bills, are legally granted an extra 3 days of grace period before default. Checks, permanently locked to demand, receive 0. Navigating this matrix only matters if the final transaction is legally valid. To close the loop and extinguish liability, the payout must qualify as payment in due course. This means the final payment must perfectly match the document, paid to the correct person in total good faith and without any negligence. If the payer acts negligently, the debt is not discharged. The entire system relies on that final execution meeting the strict standard of good faith. The Negotiable Instruments Act is the invisible infrastructure of the modern economy. It systematically converts interpersonal promises into robust, transferable commercial realities. Understanding how to manipulate these distinct architectures separates basic legal participants from those engineering high-stakes commerce.